Again, request everyone to kindly reassemble in the hall so that we can start with the next working session. And those who are already present inside may please settle down. So now post-lunch, we have our working session number 2. It's on impact of PDP Act on industry. And the session is being chaired by Dr. Pinky Anand, Senior Advocate and Vice President, Bar Association of India. The speakers are Shri Ashish Aggarwal, Head of Policy, NASSCOM, who is already here. I request you, sir, to kindly come to the dais. We also have Ms. Shahana Chatterji, Partner, Shardul Amarchand Mangaldas. Ma'am, please come to the dais. And the third speaker, there is some change in that because Mr. Bibu Prasad Tripathi had some personal difficulty and he had to immediately fly back to his hometown. So therefore, in his place, we have Bagmisikha. May I request Bagmisikha to kindly come on the dais. I request now Dr. Anand to kindly start the session.
Good afternoon, everybody. We are back again after lunch. I hope you are all equally alert as we were from the morning. It's always a difficult task, though, I'll be honest. And data protection in particular is a very technical subject as far as one has seen. And we definitely have quite a few good speakers who are here, Mr. Ashish Aggarwal, etc., and Shahana, who will be speaking later on. This particular session is dealing with the impact of the PDP Act on industry. And of course, that is one of the most primary concerns. We have, from the morning, since you all have been participating, been dealing with the coming of the act, rather the bill, sorry, and the consequent implementation issues and some of the controversial issues that surround it, and we are concerned with. The idea being to analyze and to see how the way goes forward. But the effect on industry is something which is evident. We are one of the largest growing data generating nations in the world. There's no doubt on that score. We have about 4.66 billion internet users and new data being added at the rate of 2.5 quintillion bytes per day. The bar for the digital market can only be seen going up. This growth is expected to be worth about US dollars 188 billion by 2025. I mean, that is the kind of background and the backdrop that we are talking about. We are trying with the means of this bill to change the scenario from the Information Technology Act, which is the only governing legislation, into the current PDP bill, which will hopefully see the light of day in one form or the other reasonably soon, because we definitely need to have a regulatory and a bill and an act in place to regulate the usage of the data, the authority which is to be set up. There may be variation. I know from the morning you must have heard various viewpoints as to what the nature should be of the supervision, but irrespective, whatever the nature is, we do need to secure the data and also to have the positions which we have had, by the way, in the PDP bill of sandbox. I think incidentally that is one of the starting points for innovation. So therefore for the industry, the sandbox concept, which permits exceptions to the question of data privacy, is one such form which recognizes innovations in the system and therefore is an incentive for the industry. We have done the PDP bill in accordance with Article 51, needless to say. We have various online platform services, Aadhaar, Passport Seva, Open Data Stack, MCA 21, GST and Unified Payment Interface, WRIS, Disha, Bhuvan, ISRO, etc. So I mean, there again, I don't want to go through the entire gamut of what is available, but one of the principal issues that I would like to flag on the question of benefit of the PDP Act, the bill currently, to the industry is one of data changeability, the portable change that is permitted within the service providers. I think that itself is one of the greatest glories of the PDP bill, and it will in fact lend the way forward into an exercise as a benefit for the industry. I have already mentioned to you the sandbox which permits innovation. Because again, today we are in a world of innovation, and every day it is a day of ideas. It is a day of data, it is a day of ideas equally. So the world is migrating into that particular perspective. Just a couple more that I want to flag at this point of time in this particular session, and the rest will be taken in detail by the speakers. I think the current scenario came around, and it would maybe not have come had there been a different time, so to say. So coming back, we had ultimately the Aadhaar controversy, which started the whole ball rolling into data privacy and coming up of a regulatory framework to take care of the diverse issues that are involved in this entire process. And of course, Shyam was the counsel for the petitioner, and a very vehement counsel, and of course an articulate, one of the most articulate counsels today in this country, leading one of course. So we had this entire issue coming up starting from there. The second thing that I want to flag in this discussion is the WhatsApp take it or leave it. Now, when WhatsApp take it or leave it issue came up, in fact, the general comment of the industry was that had there been a law in place, this entire controversy would possibly not have arisen, because you would have a regulatory framework to take care of the needful. While we speak of that, I would also like to flag the blocking out of the Chinese online services that were discontinued in 2020. They were blocked. Ultimately, there was leakage, there was espionage. So the whole question of benefit to industry stems not only from the business platform, but also from securing the needs of the industry to the extent their benefits and their data and their development and innovation. So in each of these ways, I think the entire scenario, I wouldn't confine it to the PDP Act. I would say the regulatory framework, the thought process, all of our concerns being here is something which is of immense benefit to the industry. And we, as lawyers, as service providers in our own way, are working towards that objective to promote the industry, to make it an even higher ease of doing business scenario in the world. So with this, I would like to take the stage forward to Shri Ashish Aggarwal, who is, Anindita has already informed, is the head of policy of NASSCOM, and indeed a lead figure. In fact, he was having a conversation just during lunch, and he focuses on the regulatory framework on data, e-commerce, social media platforms, fintech and telecom value-added services. He was earlier at the National Institute of Public Finance and Policy, where he led the technical assistance to the Indian Ministry of Finance. Earlier in his career, he was also part of the team that designed the national pension system. So there's a lot of designing and policy for you. Ashish, would you like to go there?
Hello, good afternoon, everybody. So this is my first session after pandemic in person, so I'm doubly delighted. And thanks to the Bar Association of India for having this session and inviting me here. What I'm going to do is to really, Dr. Anand, please stop me when I'm out of time, because this is a topic I can just talk on. So when, at least wearing a NASSCOM hat, when I think of a law, I think of it like a software code, and how nice that would be. So you write a code, then you use dummy data to test it, you fix all the bugs, and when it goes live, pretty much few glitches and we are on, right? But law is one software code which typically doesn't work like this. And if you think of the process, I think this data protection bill is testing our lawmaking process to an extreme, just because of the way it is. And just when I was driving here, I was chatting with my colleagues on phone in terms of, is there any other law of this scale which protects, which has been designed to protect and operationalize a fundamental right? So if you think of all other laws which are there, which probably operationalize a fundamental right, in my view, in our view, they're much smaller in scale and relevance. And some things like right to freedom, right to equality is probably embedded in all other laws, and there's no vertical law for it. So just in terms of all that scale, this is mind-boggling. When you think of the industry, Dr. Anand told you about some numbers. What is unique about India? There is no other country in the world which is the IT services hub to more than 120 odd countries. And we, as a developing country, doing this is even more an exception. So we have clients in over 120 odd countries. We serve most of the Fortune 500 countries in the world. We are clocking this year estimated March 22 numbers, exports about $178 billion. Domestic market is going to touch $50 billion just now. This doesn't even include the e-commerce numbers. So when you think of all this, we are very different when you think of data protection law from a Europe or an American perspective, just because of the way our industries are positioned. And then you look at our own, in terms of heterogeneity of our population. If we thought consumer protection was a thing where a lot more needs to be done, just making people understand privacy as their right and operationalizing it, it's going to be something worth doing and going to be a big challenge. As an industry, we are adding 500,000 people roughly as a net hirer every year. So even as an employer, how it impacts us as a business is going to be tremendous. We now have 25,000 tech startups. About 7, 8, 10 years back, this number was less than 1,000. All of these companies are wanting to be unicorns. Some of them would naturally be global. Today, they might have a very inward-looking domestic perspective, but that could easily change as we grow and this industry matures. So from all of that perspective, this law is crucial for the industry. And when I speak on behalf of NASSCOM, I'm not going to wear just an industry hat, because unless we get the privacy part of this law right, this is not going to be really helpful. Because what privacy protection will do is to increase trust in the digital markets. And that's going to power the next set of growth. Without trust in the digital market, we can be sure that we are going to struggle as a way to progress the digital economy. So that's the opening in terms of why it is important and what's the position that I'm coming on. Now, in terms of just the institutional capacity, I think joint parliamentary committees working on a law was probably something, a very useful way of doing this. It still can be, but just reading the joint parliamentary committee's report, I think they need much more powerful secretariat. They need much more capacity to do justice to the mandate which they have been given. So therefore, if I think of the journey from 2018, we have probably moved 4 steps forward and then half a step backward. So this is something that we need to get it right. So while as industry we want this law to come in soon, we also want it to get it right. Now there are 2 big positives. Of course, enhancing privacy, and second, this law being a horizontal law, which is also unique, because how do you deal with this? And I'll come to that. Some major flaws which I want to point out from an industry perspective. So we just talked about the fact that dealing with privacy in a horizontal law is going to be a task which is a very high order of magnitude. Now what the government is trying to do is to also plug non-personal data regulation with this. Now, without even getting into the debate of whether we need a regulation and in what form that law should be, it's like you have one wheel which has still not set in, and you have put another important or complex wheel along with it, and you're trying to set it right at the same time. So in the GDPR, we are speaking to, our industry has good experience of implementing GDPR. We routinely speak to lawyers in implementing GDPR. What is the single most important concern? Just the compliance. And what compliance? Record keeping. Lot of people run business, but a lot of businesses don't document everything they do. Just as an example, there is a customer and there's a target customer. There is so much of data of a target customer which is captured. In GDPR, in PDP, the way you will be required to manage it, most of the businesses are currently not geared for that. So separation of non-personal data from this, and you can amend the law later, you can do various things. If you want the same authority, there are multiple laws which can have same regulator, so it's not a problem. Second, weak privacy interoperability. Now this is not an inward-looking law only. It is a law which will talk to the world, because that's the whole idea of a shared economy and a global economy where you can actually do business in a manner where it suits in terms of business benefits. So just 3 points on where this gets weakened. Data classification, very fundamental. So the way we classify sensitive personal data, we have official identifier by default as a SPD. Now, just my Aadhaar number, my passport number, I can give you so many use cases where it is just going to be processed on a daily basis. You getting your even visa and so on and so forth. Now, as soon as you classify that as a default SPD, imagine the cost. So what the GDPR has done, it has said that nations can, or authorities in nations in EU can provide additional safeguards for official identifier based on risk. So they're being smart about it. They have kept that thing with them, but they have not hard-coded the law. Second thing, I mentioned about the India's large data processing industry. How do we deal with the processing of foreign data in India? So it's a 30-year-old industry and it's been working very well, right? So the opportunity is to say that, look, now without data protection law, we have had so much success. So this should, quickly make it 5x, 10x. But right now the law has no clarity. So right now the law does not deal with how it will treat the foreign data getting processed in India. And if you take the classification of data the way we do it, and I mentioned official identifier, financial data is not by default a sensitive personal data in any other law. Health data in GDPR is also defined as data in relation to my health. It is not all the data which is processed as part of my health processing. So my application form number is not health data as per global benchmarks, but in India it will be. There is study in GDPR again that how it takes the cost of healthcare up in Europe. So imagine in India a spectrum, there is a Tata Memorial Hospital and a dispensary in a village. Both will need to comply with this law. Think of global organizations which are maintaining their ERPs or certain manner in a certain way. How will all of this be complied with? Just because we have some definitions which are wide and some definitions which are probably need a relook. Foreign data processing, I was saying. So what we need is a clarity that once we are processing European data or US data or anywhere, they constitute 70% of our industry's market. Basically, we will give precedence to their laws as to when we are processing it, and any unique feature which we have in our law, for example, data localization. So now you can't have data localization apply at least to the foreign data that is getting processed here if it is sensitive, right? Now today there is a enabling exemption clause. Okay, हमने एक डाल दिया है, we have a clause, we will exempt. But industry doesn't work with that kind of a uncertainty. We need a very clear provision to say that how will you allow processing of foreign data in India? So that's issue number one. State exemptions. So we are not a civil activist group, but unless there is a clarity of independent oversight and how these state exemptions will work, this law will not be interoperable with the world. So you have in section 12, where you have inserted the word including, which means state can process any data without consent. Then you have section 35, which is saying exemption can be given for expedient reasons. So if you look at the dictionary reading of the word expedient, it's something which need not be right, but it is required. Then you have section 36, which gives you upfront exemptions for preventing and detecting crime. And it says that this exemption is actually available even for private organizations. So it is not even bound to state. So in all of this, you need adequate checks and balances. So again, if you compare the European construct, they have a separate law called Law Enforcement Directive, and they have separate laws which have protections on how state will use the data. So I'll quickly move to the next bit, ease of doing business. So default localization for SPD. Now you may want to have localization. Let's not even fight that battle. But why make it a default? Why tie your own authority with it? Why not give it a menu of option and say that if there are 200 countries in the world and we have problem with 20, we will do data localization for data transfers to those countries. Why make it a default for the entire world? Second, hardware certification. Very good, cybersecurity is very important. Deal with it in the IT law. The idea that we should solve all world problems in one law is problematic. Same applies to NPD. Age gating services to minors. A child of 14 can decide custody, has a say in whose custody he will be vis-a-vis his parents. But when it comes to internet services, we are sticking to 18 as a default for contract. We need to think about it. So can we have a lower threshold and then give the authority the power to say that, look, on a case by case, on a risk by risk basis, they can have differential age gating, and that could be something useful. For data transfer, You need consent for each data transfer that will happen internationally with India. So what kind of state capacity are we imagining? Because data transfer is par for course. And you need double approval. You need approval from the authority and the central government for each. And then you have a clause which says that the government can examine whether the contract or intergroup scheme for transfer is fit under state policy or public policy. What does it even mean? So are you going to examine each contract to check whether it fits the state policy or public policy? Imagine the kind of effort that will require. Last, look at the authority. I talked about independence of the authority. Now, we want to have, in terms of selection committee, a certain representation. That's very good. But you need to think about it. So for example, just we were discussing that if the Attorney General is part of the selection committee, and later on, when the government is getting sued under data protection law, it is the same AG which is going to be defending the government. So we should think about the construct so that the law is not only, the authority is not only independent, it is seen to be independent. In most of the laws, the government can specify the terms of service of the authority members and staff, but they can't vary those terms after appointment. In this law, that's not clear. So that's problematic. In most laws, government has power to issue directions. In this bill, as it stands, it can issue direction on any matter and not on policy matters only. So these are problematic because we don't believe that everything will work very well just because we'll have few good men. We need to make sure that the law puts accountability at a level where independence therefore becomes much more, relevant. So I'll just conclude. I think at first we have this view that, the law can't be fixed. It's too problematic. But actually that's not the case. We have looked at it, we have done clause by clause analysis, and we actually feel this law can be fixed. It just requires a understanding, like I said, think of the law as a software, do the use cases, take real examples from the world and see how they will run, and you will figure out the problem and you can solve it. So happy to talk later if we have more time, but thank you.
Thank you so much, Ashish. So I think Ashish's two conclusions. One is one shoe doesn't fit all. So that's one of the discussion points, I guess, in some fashion. And secondly, his positivism on saying there may be flaws in the current situation, but definitely ones which are resolvable. So Ashish will use all your talent and your skills and your analysis to hopefully take this way forward. Maybe you can share them with us. We now have Shahana Chatterji. She's with Amarchand Mangaldas. Shahana has been deeply involved with policy and regulatory issues in India and US. She's worked with a representative at the US Congress, Washington, DC, engaging in expansive legislative and policy matters, ranging from healthcare and financial reforms. She's working also currently on policy matters, specialization in data and technology, healthcare and pharma, food and beverages, agribusiness and retail. So pretty much unparalleled understanding of the current cutting edge issues. Shahana, the floor is yours. Yes, please.
Thank you so much, ma'am, and thank you to the Bar Association for organizing this event and for calling me onto this panel with very distinguished speakers. I'm Shahana. I'm a partner with a law firm based here in Delhi, and I focus on data and technology issues. And what I wanted to do today is present a slightly different focus to the developments around personal data. And as practitioners here, I thought it might be helpful to talk about some of the issues that we need to be aware of as we are going to be working with our clients. Now, the topic, of course, is about the impact of the bill on industry. And I was asked once in very early days about, which is the industry that we think that this bill will have the maximum impact on. And the answer is that there is no one industry like that. This bill is meant to be horizontally applicable. It is meant to have extraterritorial applicability. It is meant to work with other existing laws. And so what we are going to see as practitioners of the law is that this is going to have an impact on every single sector in the country. This is quite definitely going to be the game changer in how our clients operate, in the kind of business models that they have traditionally used, and the kind of legal advice that we will have to be providing to them going forward. So there is absolutely no doubt that this is going to be, this is a law that is going to have massive impact on industry. And given that the ambit, the scope of this law is also evolving, because if we look back to when the expert committee under Justice Sri Krishna was set up to examine what the regulatory framework for data protection could look like, the competing interests or the different issues that the committee was dealing with has evolved over time. And we see now, after the Joint Parliamentary Committee has examined the bill, that there are added concerns. So where the law kind of germinated from the way, Dr. Anand and Ashish were articulating, that it was about how do you safeguard and implement this fundamental right, and how do you balance it against the needs of innovation, against the needs of industry and commerce. We see that there is also now an added element of how do we protect national security. Because individuals' data, especially at a community level or at a national level, is becoming an issue of national security. So there are these various competing interests that the lawmakers are trying to grapple with in order to come up with a law that works for everyone. Now, good or bad, right or wrong, those are separate issues. I thought it would be helpful to talk about what I see as 6 issues that is going to impact our clients, irrespective of which sector they are in, irrespective of what business models they have, irrespective of what operations they have. Now, the first, of course, is about applicability. So like I said, that this law has extraterritorial application, which means that this law is going to be applicable to entities who may not even be incorporated, who may not even be set up in India. It may be applicable to them if they are doing any sort of profiling of individuals here. It may be applicable to them if they are providing any sort of systematic services here in India, right? So this is not a law that is going to be limited to entities that are set up and operating in India. This is going to have extraterritorial application. This is also going to be a law that will have horizontal application. And by that we mean that there are absolutely no exceptions to the kinds of sectors, to the kinds of legal entities, to the kinds of operations to which this law is going to be applicable. And the reason for this was because both with the expert committee and with the parliamentary committee, there is a very clear understanding that, listen, it is the data subjects, you and I, who are at the center of this law. And it is our rights that we're trying to protect. And with that focus in mind, the idea was to make this law extremely expansive and applicable to anyone who deals with or processes data here in India. Now, the other issue is of consent. And this, to me, is one of the biggest challenge that we are going to see in our everyday work with our clients. And the reason is that the law, the bill rather, that the way it's currently set up, is that consent is the primary ground for processing. Now, what does that mean to us? This basically means that any time anyone processes our personal data, and of course sensitive personal data and critical data, it will have to be on the basis of consent that is provided by the data subjects. Now, there are slightly different standards of how consent has to be obtained, depending on whether you're just processing personal data or you're processing sensitive personal data. But the reality is that most of our clients are going to be processing mixed data. And by that I mean that it could be elements of personal data, which could be my name, my phone number, my address. It could be elements of sensitive personal data, my vaccination status, my health status, my financial status. And it could also be elements of critical personal data. Now, today we don't know what that looks like because that is to be defined in the future. But in reality, in practicality, most of our clients will be processing mixed sets of data. Now, what does that mean for them when they have to process that data, when they have to collect that data? How do they obtain that consent? Will the consent be sufficient for the kinds of processing, for the kinds of use to which they're going to put that data. So anything from a sales call for the sale of a car to me going to a financial institution to get financial services. Any of that sort of processing of data is going to have to be based on consent. So a lot of the manner in which data is collected, the manner in which data is stored, the manner in which data is used by our clients will only be permitted if there is adequate consent from the data subjects. So we are going to see a lot of issues around, is this consent adequate? How do I maintain this consent? What if I want to get additional data from my customer? Do I need to go back and get consent from them? So we're going to see a lot of questions around how consent management has to be operationalized and implemented. The other set of issues is around the data subject rights and what that means for identification of who is a data fiduciary and who is a data processor. Now, before I get into the intricacies of that, the bill today is offering very unparalleled and very significant data subject rights, which till now haven't really seen any sort of expression in law in India. What we have so far currently in India for data protection is in the form of subordinate legislation that gives very superficial types of rights to data subjects. The kinds of rights that are now being given to you and me as data subjects are phenomenal. They are very detailed, they're very well articulated, and there are mechanisms to try and balance how those rights are going to be implemented. Now, apart from that, the sorts of rights that are being given to data subjects includes, for example, the ability for a data subject to say that, whatever data you have as an entity, you have to erase that data. You can no longer use my data for the purpose for which you have collected it. Now, what does this mean on a day-to-day basis for the entity who has in fact collected that data? There will have to be an identification from us as legal practitioners, as people who are understanding and interpreting this law, of who has that obligation, because these are rights that a data subject is going to have with respect to data fiduciaries, who are the entities who determine how a data subject's data subject's data is to be processed. Now that will lead to further questions about who all has that data fiduciary shared my data with. Who in this scheme of entities is a data fiduciary and a data processor? Because a data processor is going to act only on the instructions of a data fiduciary, right? So I could go to a diagnostic clinic in my neighborhood to get an X-ray. They may use third-party service providers to do analysis of that X-ray to be able to give me a result. They may even use e-commerce websites, for example, will use logistics service providers who are third-party entities to deliver the products that I have ordered on their websites. So there is a whole ecosystem of entities who work together to deliver services to us. Who in this ecosystem would be the fiduciary? Who would be the processor? Who are the entities against who I can action my rights? Will also be issues that we will see coming up. Now, hopefully there will be some clarity. Ashish already alluded to this, that there are some aspects of the law which today, just on a reading of the law, just on an understanding of how industry works today, we know will be very challenging. And these are the kind of questions that we can expect as practitioners on how do we resolve those interpretational issues given the existing business models and given the way industry practices today. The last two issues, again, you would have heard about this over the course of the day today, are on data localization and transfer restrictions and non-personal data. Now, on data localization, we know what the bill is suggesting is that for sensitive personal data, the data is stored in India. It can be processed outside of India, but it has to be ultimately stored in India. And for critical personal data, whenever that is defined, even processing has to take place in India. So there is absolutely no scope or a very, very narrow exceptions under which critical personal data can cross Indian borders. Now, in addition to that, there are cross-border transfer restrictions, which means that if certain type of data, say sensitive personal data, has to be shared with an entity outside of India, there are all of these added requirements that Ashish already discussed about getting not just the consent of the data subject, but these additional layers of approval from the DPA, from the government. It has to be tested against whether it works with public policy, etc. Now, on a day-to-day basis, we see a lot of our clients who undertake cross-border transfers, not just on an everyday basis, but also on an instantaneous basis. There is data which is shared with parent companies offshore. There are data centers who will provide redundancy from different jurisdictions. There are entities who will check global supplies to be able to tell you whether a product is available or not. So the fact of the matter is that today there is so much access to global data, and there is so much global data flows, that imposing these types of barriers, these types of challenges, or these additional hoops to get through will raise a lot of questions from our clients about whether they're compliant with these obligations or not, right? Especially where most other jurisdictions in which they operate do not have these types of limitations. Now, very quickly, I see that I'm almost out of time, so I won't discuss the NPD issue in too much detail, but I do want to flag the issue of a transition period. Now, we have seen two iterations of the bill. We have seen a joint parliamentary committee give its recommendation in its report. And there has been a lot of back and forth on a transition period. There was initially a suggestion of a transition period which would give industry almost 24 to 30 months to comply with this law. And that recommendation of having a transition period has been strongly made. Now, why is this important? It seems like a procedural matter. And the reason it's important is not just because of these substantial issues that our clients are going to have to work out with us. It also means a massive investment of resources and time and energy to rethink the way they procure technology. They are going to have to get additional employees, additional workforce to deal with a lot of these issues. They're going to have to appoint special officers. They're going to have to put in place policies for data management, for consent management, after really understanding and studying where all their data flows are. So these are very significant issues that are going to take industry a long time. And I think we do have to keep in mind that the fact that this law is applicable to absolutely everyone, from the small retailer to the biggest manufacturing entities to the ONG producers. This law is applicable to everyone. Everyone is going to have a different capacity on how long or how quickly they will take to comply with it. And so the transition period becomes extremely critical as well. So finally, just to wrap this up, these are just some of the issues that we will see as practitioners. And what I think, just to wrap up this discussion, I think as takeaways for us as advocates is that we have to keep a track of the developments under this law, because a huge number of substantive enabling provisions are actually going to be set out by the DPA in subordinate legislation and regulations, codes of conduct, etc. So that is, if we are advising our clients on this, that is extremely critical for us to keep a track on. And I think the other takeaway is that we have to understand what our clients' data operations are. It doesn't have to be a data-intensive client. It doesn't have to be an e-commerce client, for example. It doesn't have to be a technology service provider. Even a manufacturing entity will deal with data. And we will have to really begin to understand what are these data operations, what are these data flows, and what are the issues that our clients are going to have to deal with in complying with this law. So just to wrap up, I think the one thing we can expect is that this is absolutely going to be a game changer. And as advocates, to really truly advise our clients on these very complicated issues. These are just some of the things that we will have to keep a track of. Thank you.
Thank you so much. So indeed, the last part of it, which I might just like to say in my own words, I think law on information and technology is one of the most dynamic situations. You ultimately have, even under the Information Technology Act, one of the discussions that took place, and you will find, of course, the same for the Evidence Act. If you go back into Evidence Act, no recognition of email and no recognition of digital, the whole world has come into its own. So definitely the dynamism of data is something which will have to be kept in mind, because every day we are evolving. That dynamism is something that we as practitioners and industry will need to cope with. Thank you very much. So now we have the last speaker. This is Bagmisikha Puhan, who's an associate partner with TMT Law Practice. She's worked in-house at Wipro as part of the GDPR implementation team, assisting them with complying with specific data privacy sectoral standards peculiar to the organization. She is standing in for Bibhu Prasad Tripathi, who couldn't make it because of certain emergency. Welcome, Bagmisikha. You have about 10 minutes.
Thank you, ma'am. So, by a stroke of weird luck, I have been afforded this opportunity to speak here today. So, and it's never an envious task to be the last speaker in any panel discussion. So, I'm going to focus on 3 aspects mostly, because like Dr. Anand mentioned, while I was working with Wipro, I realized one thing, that as lawyers, we have this habit of getting into the flow of telling what the law is instead of telling how to implement it. So the first thing I was told by my boss, who was the risk head of Wipro, was that you have to stop now thinking as an advisor, get to the brass tacks and go ahead and implement it. So one of the major challenges that I'm seeing when I'm looking at this particular bill, and something that we have been literally accosted by our clients to explain to them as to how they can find their way out of this, is the creation or the rechristening of data controllers as data fiduciaries. The minute we are trying to call them as a fiduciary and then calling ourselves as data principals, we are trying to bake in an element of a fiduciary relationship which is essentially based on trust, which is typically something we saw in the finance sector or the health sector. Now, back in 2013, the Ministry of Health and Family Welfare issued the electronic health record standards, which were eventually revised in 2016. But right at the outset, in the 2013 document, for the first time we saw in India that the data subject, or in that case the patient, was identified as the owner of the data. And under the standards, it was supposed to be the patient who was supposed to explain or who was supposed to determine what is to be done with the data that they're offering to the healthcare providers or healthcare organizations. Now from that, we have come to a point where the bill now goes ahead and says that the data fiduciary is the one who will be obligated, as in terms of preserving quality of data, to ensure that the data is accurate. Especially in a country where we see the level of forged documents range from PAN cards to DLs to a point where people do not even accept driver's license as a valid identification proof. Imagine having to advise or having a gaming company letting in a child or letting in a minor or letting in an adult actually to get onto their ecosystem to play as a player for free or for stakes. Now the issue here is that while there are options for them to probably engage, because fortunately UIDAI has API which integrates with the system of these third-party service providers or companies, where they can validate a particular UIDAI number against a particular identity, the fact still remains that it's the data fiduciary is responsible to ensure that the accuracy of the data that is being fed to it is being preserved by them. Now what happens in these scenarios is, and what we have seen especially with the intermediary laws, I'll draw this analogy because I think it's important, because Dr. Anand also mentioned that WhatsApp came up with this take it or leave it policy. Now I sympathize with them, not because I'm their lawyer or anything, but I'm just saying I sympathize with them because I understand that from their perspective, the idea was they are disclosing everything that they are going to do with your data. At least, the latest iteration of their privacy policy had more information as to what they are supposed to do with your data from a business standpoint or as a business use case than what was existing earlier. Now, looking at how Twitter has come to a point where it's not just, deciding whom to offload from their platform for the sake of trying to, becoming the vigilant that they are expected to be under the law. Imagine a scenario being replicated for a service or a product that I am entitled to as a data subject. As a data principal and a data fiduciary relationship is being forged here for, let's take the bare example of digital gaming. Digital gaming is a sector which has been looked at heavy amounts of suspicion within the Indian ecosystem at least. And not just from a financial standpoint or an anti-money laundering point of view, but from the point of view of the damage or probably the impact it has on the younger generation. Now, for an entity which is allowing users to come onto their platform to play any games for free or to indulge in games for stakes, if they are not able to validate a particular user, they will just offload them from their platform. And not just that much. This we have seen has become a problem with all the digital health platforms which have actually proliferated over the instance of COVID. We have actually seen that there are practitioners who have offloaded users from their platform because they are suspicious that the information or the prescription or the diagnostic lab report that the patient is actually uploading is forged. So in the event that, they probably are being pulled up later on for probably, issuing a prescription over the platform to that particular end user, it's easier for them to ensure that they do not even have to proceed with the particular teleconsultation. So it's, at the end of the day, it's on the users who have to, suffer the brunt of this onerous requirement which is being put on a data fiduciary. And like I said, personally, when we were implementing these issues from a GDPR standpoint, there were still many more exceptions which were given, which were at a higher level, and there was a lot of legroom given to the owners or to the actually data custodians to be able to innovate as to how they want to manage the data. At the end of the day, the responsibility of a data fiduciary is to determine three things. What is the information they require, how they want that information picked up, and why they need that information. So where we are allowing this access to be provided to the data fiduciary to determine these three elements, there is an element, there should be a requirement which also affords them the opportunity to put some liability on the user who is actually submitting that information. Like we, of course, sign up to disclaimers and to terms of use and privacy policy where we say that the information I am submitting is accurate, but then to have a parallel requirement on the data fiduciary to ensure that accuracy, it will not just increase their reliance on third parties, which will also actually increase the amount of information that they have to share with the third parties. Imagine an employer who has to hire an employee for a simple validation of a particular certificate. They're not just going to engage a particular background check vendor for this. They're also, like I gave you the example of UIDAI open API, they have to actually set up a team or probably outsource that function because there are existing platforms who do this. So it's not just about a compliance check that has to go into their books. It's also a cost burden that's being faced by the private sector. Now, moving from that, the second issue that also Ashish mentioned during his discussion was that there's a level of awareness that we have here which cannot be compared to what's there in the European Union or for that matter in Australia or Canada or US. Now what's happening is, if I'll just actually not delve deep into the law, but I'll give an example. Very recently there was this case in Guwahati where an Ola electric scooter was used and there was an accident. So the person of the father of the person who suffered from that suffered injury from that accident actually put up a Twitter post saying that it's the unsound or inefficient services provided by Ola scooter services that led to this accident, and probably his son would have not suffered from those injuries. So Ola in turn came out with their analytics and they shared it on Twitter, to which the person who was actually maneuvering the vehicle went and said, "Ki you are publishing my personal data. I did not sign up for this. I did not consent to this." The differentiation here, what is essential to understand is what is PII and what is personal data. So when we have tried to gone ahead, we have gone ahead and actually added new definitions and new classifications altogether, what is lost in transition is that people do not understand the distinction between what can be a particular identifier which requires other information sets to be used in conjunction to identify an individual, as opposed to something which can directly identify an individual. So what happened when Ola published that report of telematics? They said that this is merely information about the vehicle, as to when the vehicle was probably being driven recklessly, as opposed to when the vehicle was driven in a manner which could not have probably caused an accident. And fortunately or unfortunately for the individual who was actually maneuvering the vehicle, they realized that this is something they have agreed to within the Ola electric vehicle policy. So the privacy policy had clearly mandated that in the event where I have to protect my legitimate interests Or I have to, at least disrepudiate claims of people telling me that my services are unsound or they are not efficient or up to mark. I have to go ahead and publish reports where there's a need to be. So in terms of awareness, it's not just consumers who need to know what their rights are, it's also the technical teams or the companies who need to be very careful as to how they're classifying the information that's coming their way. And if they're able to, because all of us here have already discussed that when you are compiling data sets or you're merging data sets, something which could have been only personal data now qualifies to be sensitive personal data, or tomorrow may qualify to be critical personal data. So these things have to be mindful, not just from the point of view of the consumer who is feeding in that information, but also from the point of view of the data fiduciary, the processor, who is processing and churning out that information, because this will also have an impact in terms of enforcing right to data portability. That I will not discuss. Finally, my last concern is the prevalence or the requirement of having intra-group schemes being verified as at this stage of drafting itself. We saw recently that with the invalidation of the privacy shield in between the European Union and the transatlantic privacy framework, we saw that what saved the major companies was the Microsofts, the Facebooks and the Googles, was that their reliance on privacy shield was at the least. They were heavily reliant on standard contractual clauses or the binding corporate rules. So what happened when the entire framework was invalidated, they were not left in a lurch. They had, because like Shahana here mentioned, that there are instantaneous transitions or transfers that are taking place on a real-time basis, on a daily basis. They were not suffering from any latches, or they did not suffer from any lapses in the services they were affording to their end users, because they already had BCRs in place. And for conglomerates of this nature, which we also have in our country, the IT and ITES and now the banking segment also, with conglomeration of this shape, size and nature, it's essential that they can fall back on schemes which are there in place, which also adhere to the same principles that are imbibed within the law, which require you to go for an adequacy or every other thing. The concern with cross-border transfers here in India is that not just consent is the bare minimum requirement, everything else has to be on top of consent. So there's a rider, there is the operative term being and. It's not, you either take a person's consent or you process it on the basis of other information which is being provided. So these are three major concerns which I have personally seen, or we have personally seen, that clients do suffer from, and they have not just, increased in terms of the cost or the compliances that they have to undergo, but also in terms of the tick marks in terms of law, or probably, like I mentioned, the cause or the cost for sharing of information with multiple other vendors has actually increased. So I think these three things are from a point of view that we have seen as a challenging scenario from a practicing point of view. So with that, I think I have not overstepped my time. Thank you very much.
Excellent. In fact, I think Bagmisikha rose very, very brilliantly to the occasion. For a youngster, definitely coming through very well. At least I think she's young. There's very critical points. In fact, critical demarcation between data which is sensitive, critical and regular data is one particular area I think she identified, and it is of importance. We seem to put everything under one bracket, but actually data falls into different categories, and particularly as far as personal and industry is concerned, you have two different platforms. And to what extent you should be able to govern the varying types of data, of course, will develop in due course of time, but there is broad identification on these three areas. As a matter of course, when during Aadhaar also the arguments were being made on privacy, one of the issues was whether it was critical data which was being shared, it was sensitive data, or it was regular data, as in your name, phone number and all those details. It was the government's contention that it was the name and only those details made available which were in public domain as such already. So we come to a close of this session. I think the industry has participated very actively, and we as counsels, as lawyers, will do our best to participate equally well in this discussion, because law has to go in tandem with industry, with business requirements, and that is where the focus area would be and should be. So the feedback that has come from practitioners who are working along with the industry is indeed a very useful one. Ashish has promised to share his paper with me. I would also ask Hana and Bagmisikha to share, if you will. So thank you everybody very much. With this we come to a close of this session. Thank you, Anindita.
Thank you, Dr. Anand, for chairing the session. Thank you to the speakers. There is just so much to learn. I think as lawyers, we are all overwhelmed to hear really the youngsters, and there is so much to learn. And all my colleagues over the lunch and otherwise, they're all saying that it's good that we are having this discussion, because this is just the beginning of the discussion in our learning process. Thank you so very much for educating us. Now it's time for tea.
Just take it.
I request everybody to please come back and reassemble in the hall so that we can start the next session. The next session is on data governance within the Personal Data Protection Bill and Criminal Law and Privacy. The session is chaired by Mr. Shyam Divan, Senior Advocate and Vice President BAI, and the speakers are Mr. Rajiv Duta, Senior Advocate and Chairperson BAI Senior Advocates Forum, Dr. Uday Prakash Warunjikar, Vice President Bar Association of India, Ms. Anita Gurumurthy, Executive Director and Senior Fellow IT for Change, and Ms. Vrinda Bhandari, Advocate. Over to you, Mr. Divan.
Hi, good afternoon, everyone. I'm sitting in here and as a substitute batsman for Mr. Jaideep Gupta. Jaideep, the perils of organizing a physical conference these days is that there is invariably going to be some dropout or the other. And that happens not because of any lack of commitment on the part of the speakers and the moderators and the chairs, but it's because we all find ourselves in a situation where if you start coughing and then you take that RT-PCR test, or somebody else around you does the same, or you're in a conference with some colleague who, pings you with a message and says, hey, I've just tested positive. It just remains, it's just smarter and better to be, to drop out of a function like this. And I recall when we were working out whether this should be a physical conference or whether it should be a virtual conference or a mixed kind of hybrid, we realized, I think, that we were running a little bit of a risk, because you just don't know with these waves whether they're going to go up or down and come crashing into, the best intended sessions. But anyway, here we are, and I'm delighted to be the substitute batsman. We have a very powerful panel. We'll follow the program. And so we have my good friend, Mr. Rajiv Duta, Senior Advocate, and I'll just dive into his bio very shortly. Rajiv, and then we're followed by Uday Warunjikar from my parent High Court, the Bombay High Court, who's sort of especially come down to participate as a speaker over here. And then we have Ms. Anita Gurumurthy and my friend Vrinda Bhandari, who I will introduce as a sportswoman first and probably a lawyer later. There is a lot to be said about each of them. Rajiv Duta is one of our most distinguished senior advocates before the Supreme Court of India. I noticed from his biodata an aspect which I didn't quite realize, is that he is spending a huge amount of time as an arbitrator in great demand, as well as a mediator, both in national as well as international fora. He's the country representative of India for India in the International Bar Association Mediation Committee, and of course, very important, he's holding office in various capacities at the Bar Association of India as well. Uday Warunjikar is very importantly the president of the Consumer Courts Advocates Association Maharashtra. I know for a fact that he's sort of extremely active and passionate about ensuring that our consumer redressal fora have personnel of integrity and competence, and he's spent a huge amount of time ensuring that we get quality access to justice in that field. He has an LLB, an LLM, and I was very happy to learn that his PhD thesis is going to be published and released to the public just in a few days' time. So that's another feather in his cap. He is a member of the Bar Council of Maharashtra and Goa, which is the regulating body, as you know, and which was good enough to issue me a sanad. So that's nice to have in your sort of pocket. And of course, he's Vice President of the Bar Association of India. Anita Gurumurthy is a founding member and executive director of IT for Change, where she leads research on the platform economy, data and AI governance, democracy in the digital age, and feminist frameworks on digital justice. I find that she's associated with a large number of bodies, including the United Nations Secretary General's 10-member group in support of technology facilitation mechanism, the Paris Peace Forum's working group on algorithmic governance, Save the Children's ICT4D Brain Trust, and Mindaroo Tech and Policy Labs Board. Vrinda, as I said, I will start from the bottom of her impressive CV. Well, not quite the bottom. She's a very talented sports person, having run several half marathons, and is currently co-captain of the Oxford Women's Blues basketball team. Is this dated? This is a stat dated. But she received her her undergraduate law degree from the National Law School, NLSIU Bangalore. But she's a very accomplished lawyer and has received distinctions and awards during her academic career in the field of comparative human rights. She knows we've worked together on some pro bono, or at any rate low bono cases. And that's been a great pleasure and a growing experience for both of us. So with that introduction, may I request Rajiv Duta to share his views on data governance with Personal Data Protection Bill and criminal law and privacy. So we haven't sort of left out anything.
Good afternoon, everybody. I feel a kind of little out of place today because one thing is that there is a lack of, that technical know-how and technical knowledge, and I must tell you that even as a senior advocate, when we started working more online during the COVID, some of me and my friends, we often used to talk to each other and say, I'm in a real big problem because I don't even know how to operate my computer very well. But anyhow, we sort of managed and scraped through it, and we don't know whether we are now out of it or not. I was just noticing on the panel who all are wearing the masks, and I think my friend on the left of me was wearing 2 masks. So I said, okay, I'm safe. Now Anil is, now Shyam has also put on a mask. See, I will tell you very frankly, I was here in the previous session, and what I heard from the speakers over there is that there is a whole lot of wisdom that is being thrown into this bill. It is been drafted by one of my most favorite judges in the Supreme Court, Justice B.N. Shri Krishna. He was a real gem of a judge and a person. And I am aware of the fact, and I learned this, that once he drafted and gave the bill, there has been a lot of tinkering with the bill by the government, and he's very unhappy. I once met him and I asked him, and he says they have completely changed my draft. So that is one thing which maybe it's evolving, as I think somebody put it earlier, that it's evolving, that now we have the committee looking into it, and probably what other disturbing factor is that once the bill is put in the House, with the kind of the manner in which the lawmakers are making the law these days, I mean, it's left to not any imagination, because we all know what has been happening, how the laws are being passed. So somehow or the other, something will be sustained. Then the next thing which worries me is this game changer which we are hearing about, how it is going to affect the working of the courts. It is really going to, and we who work as litigators, I am a die-hard litigator in the courts, and I see how our courts are operating at High Court level and in the Supreme Court. I fear, are we really ready? Because it is going to give rise to a lot of fodder for the lawyers. A lot of litigation will set in. Even when the Commercial Courts Act came and when we went to High Courts, the judges were taking their time. Arbitration law, you all know what has happened. So what I will begin with, and I'll make my, whatever I'm going to tell you is going to be very limited and only from the point of view of an advocate or from a point of view of a lawyer. See, we lawyers, right from the beginning, what is ingrained and etched in our mind is 2 articles of the Constitution, of course, the Constitution also, but Article 21 and Article 20, sub-Article 3. Now, it is that has made our foundation, and by which we have led our whole career in protecting the right of the clients that who come to us, etc. And protection of life and liberty, personal liberty has been a passion with many of us. Subsequently, also when we delved into some intricate problems arising out of protection to life and personal liberty, and when we read and we actually in practical saw how the accused were, they were being compelled to be a witness against themselves, and there was involvement by the prosecutions as to how they can rope in, and we are all aware of how our prosecution agencies work in our country. So that is another aspect. So now the background of the bill, you all know. It's whether I should call it the starting point or not, I am not very sure, because Puttaswamy's judgment was delivered by the Supreme Court in 2017, and what has happened was that the writ itself was filed in 2012. And what is it that the Supreme Court said in Puttaswamy? It was nothing, but they said that the most important thing that they said was that, and it was a unanimous judgment of 9 judges, and it held that it is an intrinsic part of life and privacy, and it's a natural right. Now what has happened is, after the judgment came, when it held that right of privacy may be restricted only by the state action, the state got into action. That is what has happened, and that is how the state is trying to somehow develop tools as to how to not really restrict, but how to maneuver and deal with this situation, because we all know basic structure and we all know that they can't tinker with our basic rights. So the first thing and the first point that I feel which is very important for this bill to measure up to is the state action has to have a legislative mandate. That is the first thing, and that is the effort that they are making actually. The second is that it must be pursuing a legitimate state purpose. It can't be that the state one day will get up, and we know how arbitrarily the agencies of the state work. So the most important thing, second thing is, first is there has to be a legislative mandate, which they are trying to work on. And the second is that it must be pursuing a legitimate state purpose. And the third and very important aspect is that it must be proportionate, that is, Such state action, both in its nature and extent, must be necessary in a democratic society, and the action ought to be the least intrusive of the available alternatives to accomplish the ends. Now, these are all pure, simple words in black and white, but how it will actually happen is something. What comes to my mind also is, and I want to share with you, this the way how it is going to affect an individual. The aspect that we are most concerned with as lawyers is how it will concern and how it will lead to and change in the life of the individuals. I am sure you must have at least I don't know whether you have seen it, but there was a comic video which we all saw on WhatsApp, where this gentleman, he goes, he rings up a pizza company to order a pizza. And as soon as he calls up the pizza company says, "Oh, you are so and so." He said, "Oh yes, okay, I am so and so." "Oh, and you live here?" "Oh, yes, I live here." "All right, now what do you want to order?" So he says, "I want to order this pizza, and I want to order with this toppings and that toppings and all." And the person on the other end says, "I'm very sorry, but as far as your medical details are concerned, I'm very sorry, you can't order such a pizza. Your pizza has to be like this, like this, like this." He says, "How do you know? How do you know all this?" So she says, "Well, we are connected." And the man is surprised, and then she gives him all the details about his health, etc., etc. And so therefore, I mean, it's comic, but the fact of the matter is, when you go to the ground, it is going to be nothing. But the moment you go into a hospital for something, they will take out something which happened to you 20 years back, 10 years back, and also which you already overcome, etc. So the fact is that this legislation which they are making, and if I will, I was thinking of getting into the nitty-gritty of this bill, but before that, you must realize as to what are the important features which the legislators must look into, because ultimately we've had many acts which have been passed in the near future. All of them have led to a huge amount of litigation, and that litigation is ever growing, and we are not able to meet the ends. So therefore everything will have to be, it's not that it's so scary that we will not legislate. Of course we will legislate. But here there is a fundamental right which you have to take care of when you are making this legislation. So therefore, according to me, and I had the bill with me, and I wanted to read out to you all the details about the bill, etc. But I think you have been here since quite some time, and you've heard a lot of people who have spoken about this. So I am not going to get into all that. But why is PDP important? Now, after the 3 points that I made, why they are going to work this legislation, why they are collecting all the material, giving you all the opportunity, and Bar Association of India, of course, is a very fortunate. It's very fortunate for us that we meet and we discuss. This is the first physical meet we are having after the pandemic. And we are discussing such an important aspect which is going to touch our lives. Of course, when we heard the people from the industry, they were discussing a lot of money, the economic aspects, etc., etc. We need not, for speaking for myself, everything today is going to involve economy, if you're going to have regulators, then you're going to have set up offices, etc., etc. Now, why is PDP bill important? Why is it important? According to me, the purpose is to prevent the breach of privacy. Because when I started looking into it, I thought they are collecting data so that they can clamp me down. They can have something in their hand of a citizen which they will make use of. But the purpose really is to prevent the breach of privacy, because it can reveal a tool for invasion of a person's privacy. That is the most important thing. We know political parties, we know governments, and we know companies. I will include them also along with it. They are also very much a part of having an agenda. They all find it very useful because they can use this data to find the most convincing ways to advertise online. We are all aware when we order a product on our telephone, be it Amazon or be anywhere, we start getting messages after messages about the same product being sold by so many people. How do they share all this? From where is it going? And this is just the beginning. This is just the beginning. Where it will end, we do not know. And how are we protected against all that? That is very important. Then the sweeping powers of the bill will give the government a tool to overcome the gains from, see, if you use a harsh word, it is overcome Puttoswamy. Of course, we lawyers are not letting them go. I mean, as long as we have the rule of law in this country, we will not let them go. Now, we all also were made aware of the fact that what is this? The data is not only of one type. There are various types of data. The first one that you know, personal data, it is as simple as that. That is name, address and identity details of the person. Now this is what happened in Aadhaar. Shyam is here, he will be able to tell us much more. In Aadhaar, what was the problem that was brought to the court? That they are going to reveal, they are going to, I am going to be, digitally, I am going to be blocked, etc., etc. They said, no, we are not going to do anything like that. We are only using your personal data, which is name, address, identity details, that's all. But then what happened was that it got developed further and sensitive personal data, which you know as SPD, came into effect. And that is finance, health, caste, religion, belief, sexual orientation, etc. Now this is going a little far. Then came the critical personal data, national or military security information. The fact is that all this we do not know, and an example was given in the previous session, how a company put something which was on the Twitter of a person which was not even required. So we are going from one company into an agency, etc., etc., and where we will land, we do not know. Having said that, I also want to point out now a few merits. There are, of course, there can be criticism. At the same time, there are a few merits also. And what are the merits? The first merit, according to me, is all personal data online and offline shall require the explicit and informed consent of the individual to whom it shall belong before it is collected or it is subjected to any form of analysis. I think this is one of the safest safeguards which has been put into the bill, and I think everybody was very positive about it. The second is Section 6. The Section 6 of this bill is that data collected should only be necessary for the purpose for which it is collected. So therefore that aspect also will have to be taken care of. And Section 7 is notice to be given to the person whose data is being collected. Now I think these are the safeguards and these are merits in the bill which we as lawyers, especially as lawyers, we feel that if they are kept in the Act, they will be of some safeguard. Then the important aspect is that data will help investigation, law enforcement in the country. Now we have been seeing over a long time now, maybe I won't say right from when we got independent, but subsequently I think there has been a lot of people trying to disturb our the peaceful situation that India was in and the peaceful situation that we want to have. So that investigation, of course, there are lapses in our system. The police needs reform. The military also has its own role to play. So therefore, this is another aspect which we need to check. There should be checks and balances, according to me. Then there is something about cross-border. We just heard about cross-border transfer. You know, earlier the cross-border transfer used to be only based on treaties. And that used to take a lot of time. And many people don't want to share their domestic bond technique, the knowledge or the data that they have. So many companies in this country now, like Paytm, Reliance, etc., you know, they support localization. So localization is a good aspect of the bill. I want to, at this juncture, also comment a little upon the other act that has come into being very recently. Section 53 and 53A of the CRPC have been amended, and that I just want to refer to so that you also know. Or I will just do one thing. I'll just give you a comparison, because that is already an act. The comparison which I want to make of 1920 Act with the 1922 Act which has been enacted. Now we all know there was Identification of Prisoners Act 1920, and that act came into being in 1920 because in 1919 we had the Jallianwala Bagh, and now we have the Criminal Procedure Identification Bill, which now actually has been converted into an act. What I want to emphasize on is that as technology has grown, we have to make amendments, but amendments which are useful to us and also within the four corners of law. So therefore, the shift from the fingerprint, footprint impressions into biological samples, etc., is something that we have already achieved in the criminal law. But it applies only to those who are involved in some kind of an offense, or who have been already imprisoned. So therefore, we have now made that jump. We have evolved that. There may be some problems with that also, but I think at the moment nothing has come to the courts. It has not really been challenged. But I recently read something which I thought I'll share with you, an article which I have just recently read, that it is almost putting a scare in the minds of the people, that if this is what they are going to collect. And then the most interesting aspect is that it can be collected from any person, and then it will be stored for 75 years. See, you all know the law. Earlier, if you were ever acquitted in a criminal case, the records had to be destroyed. No longer. They will all be digitalized and saved, and for 75 years. And who will use them? At what point of time? We are not so aware of. So these are the aspects which I wanted to bring out in the very beginning, so that we have dealt with the bill. If you deal with it para-wise, it's another aspect. But the fact is that the points that I have highlighted, the merits and the demerits, which will need to be looked into. Thank you very much.
Thank you very much, Rajiv, for highlighting both the strengths and the shortcomings of the bill, and also for broad-basing the discussion into this amendment to the criminal law, which is very, very important, I think, for all of us who value our liberty.